Hey everyone, Harry here to talk about the oral argument in the gag order issue from the Judge Chutkan January 6th trial, which just finished a few minutes ago. All right, let's set this up again. After Trump makes certain incendiary comments, Chutkan issues a gag order. Trump challenges it and to her, and while she thinks about his challenge, she suspends it, during which he absolutely abuses the process, trashes Mark Meadows, a potential witness in the case. She then reimposes the very same order, rejecting a vagueness challenge. We'll get back to that in a moment. And then it goes up to the Court of Appeals, which also suspends the gag order, just an administrative stay, given that there's First Amendment interests here, et cetera, just to kind of freeze things until they hear the case, which they arrange to do very quickly. And they do this morning, Monday morning. And it started at 9:30 and it went, normally for a complicated case, you have 20 minutes, maybe a half hour. I think that's what they were scheduled to have. They go over an hour with John Sawyer, Trump's lawyer, and over half an hour, certainly, with the government lawyer. So they really dug into the case. And you could see that, in fact, they were a little bit troubled. Let's start with Sawyer's presentation. I thought he basically really wrestled against the court's hypotheticals. The basic thing that's going on here, the court wants to know, is there any ability for a district court to impose some kind of, as Judge Pillard put it, prophylactic protections. You hear Trump, totally trashing prospective witnesses or sullying the integrity of the trial process in a way that when jurors come to serve, they could already think it's corrupt. Is there anything that can be done looking forward? Because in a normal political speech setting, the standard is very high indeed, the so-called clear and present danger test to be able to suppress speech before it is offered, and political speech. And they seemed to accept the idea that this was even, stuff like vilifying Mike Pence or Jack Smith was a form of political speech. I think they largely accepted its dual content as both commentary on the trial and the personnel, but also on the process and a defense to the American electorate, whom he's asking to elect him or nominate him for president of his bona fides. All right, so John Sawyer gets up there and basically continues to advance the same kind of analytical framework as one would do for a prior restraint, say, of a newspaper. And the court just wasn't having it. And he continually got himself into trouble because they would offer hypotheticals. What about this and that? And he would say, well, in this case, and I know in this case, counselor, they finally, and these are three pretty easygoing judges, well-mannered, not tempestuous, and they obviously showed their frustration that he just kept, wrestling with them on the hypotheticals that they were advancing. But they pushed on him to give some allowance for a court's ability to protect the integrity of the trial process. And for example, he would allow, say, flat out intimidating speech, but that's already a crime. So surely it's okay, to in fact, it's a part of a standard conditions of release to tell a defendant he or she cannot commit a crime. And they were really looking for Sauer to give them something. It's clear they thought about it a lot. They went around and around on certain cases, Supreme Court, but also Fifth Circuit, and they were really on top of things, and they thought about it carefully. And also, they were very conscious of the practical political setting here. There was no kind of pussyfooting around on it. They said there was no prevarication. They said flat out, Trump is running for president. Here are some of the things he said, etc. Some of what the worst stuff he had said had gone back a few years to January 6th. So there was a side question of, how fresh it has to be and the like. And I thought essentially Trump's lawyers gave them very little to work with, just basically said there's, narrow, very little that can be done that wouldn't also run afoul of the First Amendment. And when asked for concrete hypotheticals, he basically bobbed and weaved and said nothing. But then the government got up and didn't have an easy time of it either, because the court obviously had a parallel concern about this being, a classic political speech. So there was a sort of overarching question that came up early. Can Trump be treated any different from other defendants? And they implicitly answered that yes. They implicitly recognized the importance in the First Amendment setting of the fact that he's running for president and wants to make his case to the people as a whole. And his case could be kind of hard-hitting and nasty, include things like, these people who are attacking me in the political sphere are liars and cheats and whatever. And they were parsing very carefully specific kinds of statements, and would they be, on the regulable side of the case, being too direct, say, threats against people in the process. The government made a pretty big deal about what had happened here. The indictment occurs. Trump the next day criticizes Chutkan, and the next day after that, a woman in Texas gives a death threat to Chutkan, and she's prosecuted. But can Chutkan not take measures to prevent that kind of thing from happening or make it punishable? And the government lawyer was effective and reasonable and cool-headed, but nevertheless, you could see that the panel was, wrestling with what to do. I was left with the impression, one more point. The government made what I think is a very effective argument, but the panel wasn't having it, at least not completely. Said that the logical extension of Trump's position would be to invalidate under the First Amendment many provisions of the Bail Reform Act. We already have many restrictions that are imposed on defendants. You could either put them in jail or you can give them conditions of release that include all kinds of requirements. And the government said, if what Trump were saying about the First Amendment were accurate, then many of these things would be unconstitutional. Seemed like a very strong argument, but the panel said, well, we don't have constitutional opinions. This is a statute, and we don't have constitutional opinions challenging one way or another the Bail Reform Act. So, maybe those are unconstitutional and we don't know. So that did not carry the day. And just in general, you could see there was this one issue of vagueness. To say target, is that too vague? That was the point that Chutkan had refused to amend her order to account for below. That wasn't the big concern of the court either. It was just this basic, how do we frame this? Clear and present danger is, according to the Supreme Court, a balance. How do we frame this so there's sufficient leeway and play in the joints for a presidential candidate to be able to aggressively challenge the opponents and people who would be attacking him in a sense, both politically and in the process of a trial. So Jack Smith has brought charges against him, but they are in the context of an overall campaign, and of course some individual witnesses like Mike Pence. That's even more so. So I was left with the sense that the panel is going to try to tighten up what Chutkan said just a bit in order to give freer rein to the First Amendment interest. If they do that, there's a tricky procedural question. They could either affirm and just make that amendment, and then it goes back to Chutkan just to enter the order, and as of then, Trump is restricted. Or they can say, here's what the court below really needs to think about some more, even if they say it very precisely, and remand it to her, Judge Chutkan, in order to do that, which would occasion a whole nother round of appeals. Whatever she does, she can use the very words and they would trump some way to challenge. Now it would have to go up again. And meanwhile, during that time, it might be that he is not subject to the gag order yet, and he could continue to basically make all these really vitriolic and I think, dangerous statements about participants in the process, trial integrity, and the like, which, again, to underscore, the court definitely wanted to give the district court enough rein to protect, but was, very sensitive to where that issue could then bleed into potential First Amendment concerns of a candidate for president. So I think they've already been wrestling with this, and they're already started to write, and I think they'll complete it in fairly short order. I would say within a week we will see their opinion. Then it'll be important, as I say, to see what happens next, and as of when, if I'm correct, that they're narrowing things a bit, as of when Trump becomes subject to the more narrow order, immediately or after another round. And that'll be a practical issue because, as we well know, when he's not expressly subject to it, he's out there on the hustings talking all manner of trash against the process, the participants, the president, and the like. So we'll keep an eye for the exact words of the panel. I think they'll give a tempered or partial victory to the government and affirm Judge Chutkan, whom they praised, by the way, for her, conscientiousness, et cetera, at various times in the argument, but that they won't, affirm exactly across the board. And we're still not completely done with this chapter of the gag order in the DC January 6th case. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.